is Rachel and Stan going to decide to set up a trust? If they'd come to me, I would say, well, it depends on how much you have to put in the trust before we can decide you're going to set up a trust. And then I would ask, okay, well, what are the general advantages of a trust, and explain them to them. I think most of the audience here understand trusts relatively well and understand the benefits that they can give. It gives you, seamless transfer of wealth between generations. No requirement for probate and that sort of thing. It gives you asset protection in cases of divorce. Not always, but often. It does give you that asset protection. Maybe not so much in the UK. There is also, it's a great tax deferral mechanism. Generally, you're able to get the assets out of your estate for estate duty purposes if it's done properly and set up properly from the start. And you're able to defer income tax and capital gains tax, at least until any distributions are made in future.
Rachel and Stan, because they're non-doms in the UK, that is, they're both born outside the UK and have no other UK connections before they decide to move to the UK with this business. That means they can take advantage of the non-dom regime in the UK. And that does give them considerable scope to organise their wealth and using a trust, as Jaco says, to help defer some taxes that might arise during the lifetime of the company and whilst they're living in the UK. So it does give them great flexibility going forwards. It does perhaps complicate things for them. There will be trustee fees. There'll be issues about do they need to take money out of the trust structure, and assuming that they can support themselves in the UK from other assets. I think what you need to put in, what needs to go into a trust nowadays really has to be sort of assets you're not going to call upon unless you really need to. So assuming that they don't need to rely on dividend income or anything from what's in the trust, and that their income as directors of the company in the UK will support their lifestyles in the UK, or they have other assets maybe, there is great scope for leaving the wealth that's accumulated as the company grows within the trust and deferring tax. So as non-DOMs, they can do that. And the non-DOM regime, very briefly, is that most UK taxpayers who are resident and domiciled are taxed on their income and gains as they arise, and to UK inheritance tax if they die whilst in the UK on their worldwide, they're domiciled in the UK on their worldwide estates. But as non-DOMs, they can benefit from the non-DOM regime and the remittance basis, which means that they're only taxed on their UK source income and gains, but not taxed on any income and gains that arise outside the UK unless they bring them into the UK. So that's why perhaps it needs to be sort of spare income and capital that they can leave parked offshore.
As tax advisors for people overseas, you're often seen as the bad guys because you come in and all this planning that's going ahead and all this great non-DOM regime and use of trusts and deferring income, the US rules might just scupper that. So you have to think through what it might mean for Rachel. So perhaps a bit of background on that. I mean, I think most people are aware that the US taxes individuals on a worldwide basis, so citizens and residents, no matter where they are actually in the world. So it's a constant problem for Rachel to address. I suppose, putting it in context, we need to think about the rules for corporations in this context, and then dealing with a trust as well, layered on top. But perhaps corporations first. It's becoming a bit tricky to advise, actually, because we've just heard from President Biden what his suggested tax reform proposals are, and he's looking at a sort of a broad-ranging shift and most likely significant tax increases, especially in the corporate area. That on the back of only 4 or 5 years ago, when President Trump came in and did a huge swathe of tax reform that had all the taxpayers overseas scratching their heads trying to work out what they had to do with any businesses that they owned, and putting in place perhaps some planning for that. Now that's created a bit of an issue for people like Rachel, because she'll be familiar with now, I assume, with these rules, being a significant owner of a foreign company. But it's whether, for example, the Trump changes, they put in a one-off tax charge on any earnings that had been deferred to that date within the foreign corporation, and then produced another provision which is called GILTI, Global Intangible Low Taxed Income, which also sought to layer on top of existing anti-deferral provisions in the corporate arena, which known as subpart F income, where a shareholder in a controlled foreign corporation would be forced to pick up income from that corporation and not being able to defer it in certain situations. We had GILTI layered on top, which was actually effectively an additional potential tax charge on top of the subpart F rules. So it had a lot to deal with